Hey, my name is Attorney Walter Rudolph Hnot III. I'm going to be addressing a question that was brought up by the NOSCR. Let's see, it's volume 38, number 8, page 9. It's basically where NOSCR, which is the big convention group for Social Security disability attorneys and non-legal reps as well, will ask a big question, and then they'll send it over to the SSA, and the SSA will answer it. The next one I'm going to be addressing is, what are you to do if you are a solo practitioner? I'm just going to summarize it. And a judge consistently, an administrative law judge, will consistently show up 2 to 3 hours late for your hearing, or you'll have to go in 2 to 3 hours late for the hearing. What if you have another hearing that's scheduled in another office or a different location or with a different judge at that point? Okay. Their response was contact the hearing office chief administrative law judge or the HOD to explain the situation and work out the issue. Basically, call, make a complaint, have them review it, blah, 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 go through it. I wanted to actually defend the SSA on this one. A lot of attorneys always complain that the administrative law judges never give enough time to a particular claimant. That, it's, in and out, in and out, in and out. 45-minute, 50-minute hearing, boom, you're done. Then get out. In this case, most of the judges that are going to be taking that much time to get to it are doing two things usually. It could be one of them or none of them, but two things. A, reviewing the claim ahead of time. Okay, reviewing the claim ahead of time. Like before the person goes in, they'll go through the medical, they'll go through some of the correspondence the attorney has sent in, they'll read the brief. My firm sends in a brief for every single claim. Most firms, I don't know of any other firms that actually do that, but I want the judge to read the brief. The judges that pretty much know me, I've been working with for a while, in the hearing, rooms will know to go ahead and take a look at the brief ahead of time, which is good because it educates them in a summarized fashion, giving them a synopsis of what's, the issue, what are the listings, things like that. For this particular situation, they're either doing, pre-hearing review, which is before you walk in there, they're going to look at the claim, or they're working with other claimants and other attorneys and other, reps that are, having their hearing ahead of time, and they're spending more time on them. Some claims turn out to be more complex than others. I know many times I'll go into a hearing, and then for the first time I'll hear testimony from my claimant that will change the claim, and I'll have to sit back and say, okay, Your Honor, this changes it. I want to go collect this particular thing so that we can modify the claim and also include this particular aspect. A classic example is that women will, especially older women, will say only during the hearing that they were, sexually abused by such and such person when they were younger. And it's the first time I'll hear about it in the hearing. That's why when I have older females, that one of the first things I ask them right when I sign them up for disability is, have you ever been sexually abused as a child? Because that question will never get brought up, and their classic answer during trial, and I ask them during trial, why didn't you ever bring that up? Well, you never asked, and it's a touchy subject. Okay, makes sense. So, my big thing is I'm going to actually defend the SSA on this one. If you, have to wait 2 to 3 hours, then the SSA, I'm sure, will go forth and reschedule that hearing so that you can have it on another day. If you're really, really worried about that, then as a representative, just set the hearing as the 8:15 or 9 a.m. hearing. That's so that it's at the very beginning of the morning, and you can literally be one of the first ones to go in for the hearing. That way, it's not the one that's right after lunch, or it's not the one right before lunch, or the one right at the end of the day around 3 or 4 or whatever. That way you have a spot and you don't have to worry about it. If you're really worried about it, just be that person. I usually schedule my hearings, and keep in mind I usually have a couple when I go, but I'll usually schedule them where it will be like a 9 to 9-1 and a 10:31, and then basically I'll do lunch and then I'll come back and do another one. Or my favorite ones to do at around 11. The judges had a couple of them at that point. They're kind of relaxed, they're in their groove. That's when I like to do hearings. And also when I have them at 11, I don't always have to show up at another office that early. I can just go straight from my house over to the hearing office, which I prefer because I'm always constantly working, and I get a little bit more sleep then. So just something to consider. With this one, I'm defending the SSA. You'll see with other ones on here, I won't be defending them, but I do try to be neutral and go based upon what I know and what other attorneys have told me as to their issues and their experience. So take this with a grain of salt. or, you know, your 5 cents and blah, blah, blah. But that's where I stand on this particular issue. All right. My name is Attorney Walter Rudolph Hnot III. I'm with Disability Resolution PA, an Orlando, Orange County-based Social Security disability law firm. We don't make specialized, specific case-specific videos. We do general tutorial videos. We've made more general tutorial videos than any other firm for disability law, more than any other firm, human being on this earth. So if you haven't seen me or you don't know me at this point, then you've been under a rock, or this is one of your first disability videos that you're watching, which is, hello, welcome to the great genre of disability law films, And I hope you watch these, and I hope you learn from them, because education is so important, and education from my standpoint to you, it's something that will change everything. The more educated a person is, the more they can change the system that they're utilizing. And I think if a lot more claimants knew and understood the system, I think the SSA would work differently, I think law firms would work differently, and things would really come out to be a better system, All right, my name is Attorney Walter Hnot, Disability Resolution PA, an Orlando, Orange County-based Social Security disability law firm. You have a wonderful day, and we'll catch up from there. Thanks so much. Bye-bye.